Let me start by just making an observation for those government employees who are concerned about whether the conduct they're being asked to carry out is consistent with federal law. Mr. Strickling pointed to language in a committee report that he said gave them the authorization to do so. As I noted in that questioning, a committee report cannot supersede language passed into law. But what Mr. Strickling did not tell you is that committee report was a committee report for legislation that itself did not pass into law. And whatever authority a committee report might have for legislation that has actually passed Congress and been signed into law, a committee report that legislation that did not pass Congress has precisely zero legal effect and provides no safe harbor whatsoever to defying the legislative language that Congress has passed. Now, Mr. Zoka, I understand that just yesterday you and Mr. Rosenweig received a hostile letter from VeriSign's general counsel regarding the white paper that you both authored along with the Heritage Foundation expressing concerns with the transition. Without objection, I'd like to include that letter in this record. The VeriSign letter strongly suggests that if you do not remove references to VeriSign in your white paper, which the company disagrees with, the company may take additional action. I will note that it is highly concerning that VeriSign would send a letter of this nature to witnesses of this oversight committee the day before they are scheduled to give testimony. Such a letter could only be designed to have a chilling effect on witness participation and to disrupt the oversight functions of this subcommittee, which is seeking immediate answers to time-sensitive questions on an issue that has the full attention of the entire United States Congress. I would also note that it is more than a little ironic that VeriSign, which has a direct working relationship with ICANN and the United States Department of Congress, would seek to stifle individual speech in this way, which just so happens to be the main focus of today's hearing. This letter, unfortunately, perhaps provides a glimpse into how VeriSign and ICANN can be expected to conduct themselves post-transition without government authority over them. Given the allegations against you, would you like to offer any rebuttal or response to VeriSign's letter?
Well, we did issue a very brief public comment. I will say first, I've been in the think tank world for going on 9 years, and I've never received any kind of letter like that. It was not simply a correction, and we did note that there were perhaps slightly confusing word choices in our paper, and we're happy to correct those. It was, as you say, a threat. And the issue that we were getting at was simply to illustrate that actually we tend to agree that ICANN probably is not immune from antitrust suit, and that the transition probably won't change that. Our point really was to say there are still unanswered questions about antitrust law. And the purpose of the paragraph that VeriSign objected to was simply to illustrate what such suits might look like, and to suggest that ICANN is inherently tied up in very controversial auctions at which there are lots of money at stake, and ICANN has a direct financial interest. And we were simply explaining that it would be unreasonable to expect that plaintiffs would not bring this kind of suit, and that antitrust litigation, whether frivolous or meritorious, will be used to attack ICANN and to discredit it by those that would indeed prefer to push to the ITU model.
Would you say that threatening witnesses before a Senate oversight hearing is consistent with an entity that we are being told we should trust to respect and protect free speech?
No, sir, although I would just remind everyone this was VeriSign and not ICANN. And again, I'm not accusing anybody of anything. We were simply trying to explain that there are many unanswered questions. The administration says it has zero correspondence about antitrust issues, yet you heard Secretary Strickling today say that there was indeed some consideration. That didn't turn up in the FOIA request that Americans for Limited Government issued. And again, the point of our paper is simply there are many unanswered questions that would have been resolved in a better process, where the NTIA had taken public comment and had issued a full report the way that administrative agencies are supposed to do, instead of simply rubber stamping what ICANN proposed.
And today, if ICANN tried to implement a policy that threatened internet freedom, could the United States simply refuse to renew its contract?
Well, yes, sir. And that is ultimately, when I say that I support a partial transition, that's what I'm getting at. I'm distinguishing between the right of the United States government currently to interfere in the editing of the root zone file, which I agree ought to be ended. That's a partial transition. That is different from what you ask about, which is the ability to put the contract out for rebid. That is something NTIA has threatened to do in the past. It nearly did so in 2012, and it has used that, as Paul says, as soft leverage to discipline ICANN. That ultimately is the guarantor of this whole system, and I just think we should be very careful before removing that bit of leverage. That decision is an irreversible one that NTIA has already set in motion, contrary to what Mr. Strickland told you about not violating the appropriations rider.
And that's a check that goes away if the transition proceeds as the administration intends.
Yes, Senator.
Following up on that point, Mr. Horton, in your written testimony, you said ICANN exercises these powers as a global monopoly. By virtues of its powers to determine who can sell domain names online and whether they comply with standards set out in the accreditation contract, ICANN has a significant effect on the future of the Internet, and it is seeking additional powers that would further limit the openness of the Internet. A working group hand-selected by ICANN's then CEO has proposed a shift to put all of the world's information about who is registered domain name behind a single gated wall and give ICANN or its contractor the sole power to determine who is authorized to see that data and for what reason, and to audit and impose penalties against Internet users who access the data for reasons that ICANN considers improper.
That's correct, Mr. Chairman.
Now, we're told that in place of the government oversight, we should trust the international stakeholders. And I would note, Mr. Del Bianco, in your written testimony, Secretary Strickland said we should feel comfort that the Government Advisory Council requires unanimity. And yet your written testimony said, quote, several governments have had voiced dissatisfaction with the present consensus rule for GAC decisions, so it is entirely possible the Government Advisory Committee could change its method of approving advice such that a majority could prevail over a significant minority of governments. Is that correct?
Yes, it is, and that's precisely what Stress Test 18 asked. I was the first one to raise this by saying the Government Advisory Committee could change its decision-making method, but the ICANN bylaws were written in such a way that they would still have to give deference to that advice. So therein lies the fix that the stress test led to. We have changed the bylaws, Mr. Chairman, such that the governments can use any rule they want to make a decisions. But the only method of decision that our board at ICANN has to give deference and respect to is decisions reached through unanimity. And the governments resisted for 2 years on this one because they did not want to have to lock themselves into a situation where the U.S. government could, with one vote, veto what a handful or a majority of other governments wanted to do. Those are the kind of fixes that we did specifically in response to that stress test.
But the bylaws could still change.
And Mr. Chairman, the discussion of whether and how the bylaws change is true of any organization who lays down bylaws and articles of incorporation. Any articles of incorporation always include a clause that says that these articles and bylaws can be changed with a majority. But we have gone far beyond the typical assurances of a CEO, former or current. We changed the bylaws. It says it shall be in California. And if the ICANN tries to change those bylaws, it requires the approval of the community. The community can block that. The articles of incorporation indicate it has to be a California corporation. If ICANN tried to change that, it would require the consent of the entire community before they could make that change. So we have built in as many protections as we possibly can to guarantee they'll be subject to U.S. law and situated in California.
You are correct that most, if not all, private organizations have the ability to change their bylaws. That's one of the reasons why we are not typically in the practice of handing over monopolies over vital infrastructure to private organizations, because that is too much unchecked power to trust, particularly a private organization that the head of ICANN testified here. ICANN is not bound by the First Amendment. one of the great services that the United States of America provides to the world is following First Amendment principles to prevent censorship. The alternative, and Mr. Rosenweig, I want to turn to you on this. Your written testimony said, "It is my view that it is indisputable that under the current proposal, governments, foreign governments, would significantly increase their power in ICANN versus the status quo. The GAC, the Government Advisory Committee, has a power that other advisory bodies do not, an ability to convey advice to the board that the board must implement unless opposed by a majority vote." Would you elaborate on that, Mr. Rosenweig?
Yes, Senator. Before the transition occurred, the GAC was capable of providing advice to the board, that the board was bound by its procedures to seek to negotiate with them if it disagreed with that. Under the GAC's internal operating procedures at the time, that advice would have had to have been by consensus, and the board would have had to have would have been capable of rejecting that advice simply by a 50% plus one vote of the board. In practice, the board tended to seek a supermajority, but the board statutory requirement was simply 50% plus one. The bylaws with respect to that advice made two changes. One that enhanced GAC power by increasing the threshold for which it would be rejected, and the other by institutionalizing the consensus requirement, so maintaining the status quo. So in effect, from where we were before to where we are now, the threshold for rejection has gone up. In addition, and to my mind much more significantly, the GAC has been invited to participate as a voting member in the empowered community. That empowered community will have, as Mr. Strickling and all the others have said, significant oversight of the board. Indeed, that is the very methodology by which we anticipate the multi-stakeholder model for controlling ICANN board and staff activity. As of right now, the GAC has not determined whether or not to seek that position, and Mr. Strickling spoke to that as well. But in the event it does, it may very well seek to do so by majority vote, not by consensus vote. Its current internal operating procedures would suggest consensus is required for that as well, but those procedures are subject to majority rule change within the GAC. So we have gone from a place in which the board by 50% plus one could reject GAC advice, and the board had no formal say in oversight of the board, to a position in which there's a higher threshold, and the GAC has been invited to sit as a voting member. I suggested 2 years ago that one of the key tests for the suitability of this is that governments remain in a purely advisory role, and the transition changes that. It remains to be seen whether or not that will have significant pernicious effects or only partially pernicious effects. Again, a reason why I suggest at least a trial period is necessary.
And I want to make sure it is absolutely clear to this committee and to the American people. Your testimony is that if the Obama administration's proposed transition goes forward, that it is indisputable that it will give foreign governments more influence and power, including Russia, China, and Iran, and other regimes hostile to free speech on the internet.
I think the only government that loses power in this transition is the United States government. All the others gain power.
And why possibly would it be in the interest of the United States to put forward a proposal that weakens the authority of the United States and that strengthens the authority of Russia and China and Iran?
I'm not in a position to answer that question on behalf of the United States government, sir.
Well, hopefully the United States Congress is in a position to answer that. Now, one answer that we have been given by some witnesses is we should rest comfort that ICANN, once unaccountable to the United States government, once lacking any supervision, we can still be confident will remain domiciled in the United States and California. And yet, Mr. Rosenweig, in reading your testimony, you also wrote, quote, "The idea that ICANN would pack up and move has been contemplated by ICANN's leadership. And specifically, you focus on the testimony that we discussed earlier in this hearing of Mr. Shahade discussing a, quote, parallel legal international structure maybe in Switzerland for ICANN. And in Senator Coons's exchange with Mr. Strickling, it was suggested, well, perhaps that referred to something completely separate and independent and not ICANN itself. And yet your written testimony suggests that interpretation is incorrect. Specifically, you said, in July, the French Senate published a lengthy report in French building on Shahade's testimony, and the report proposed the, quote, Swiss model that would, instead of transforming internet governance to a one-country, one-vote system like the ITU, have ICANN assume international legal personality as a, quote, world ICANN on the model of the Red Cross. Is that correct?
That's my understanding of the French Senate report, which I also understand to have been in reaction to Mr. Shahade's testimony. I do not know if that translation from Mr. Shahade to the French Senate was accurate, but it certainly is their interpretation of what he was saying.
And one final question. Your testimony also gets into the .mil and .gov top-level domain names. And it is that there is no concrete assurance beyond an exchange of correspondence that .gov and .mil will remain under the control of the United States government. Right now, for consumers, that is an essential consumer protection. If you go to senate.gov to see official government records, you have some degree of confidence that that is not an illegal scammer. If you go to irs.gov, you have some degree of confidence that this is not a phishing scam designed to perpetuate identity theft. Under this transition, there's no assurance .gov and .mil remain with the United States government. Is that correct, Mr. Rosenweig?
There's no assurance beyond the letters that have been exchanged, which, as I understand, are not enforceable contracts. To the extent that you think that the letters are themselves an assurance, then they stand in that stead. But I am puzzled by the argument that entering into a contract about these is somehow a derogation of sovereignty. I had not heard that until Assistant Secretary Strickling said that earlier today, and so I hadn't had the chance to think about that. But the government enters into contracts about its intellectual property and other property all the time. So I want to see that analysis and think about that some more. I don't have that piece of answer for you.
Okay, thank you. Senator Coons.
Thank you, Mr. Chairman. This has been